Hello, brothers and sisters. How are you guys doing? Hope you guys are doing amazingly well. Yeah. So, RTP, we are now discussing Division B, descriptive questions. Division A was multiple choice questions, MCQ, which we have already discussed and have uploaded in the YouTube. Hope you have watched the video. Now we'll go with this Division B. The paid-up share capital of Golden Shoes Limited is 25 lakhs, which is divided into 2 lakh 50,000 equity shares of rupees 10 each. Some of the shareholders holding 2,500 equity shares are resident of London, for whom a foreign register of shareholder is opened there on November 1, 2022. Advise Golden Shoes Limited within how much time after opening of foreign register it is required to file with the registrar of companies a notice of situation of the London office. So what is this? So what is this foreign register? Where register of members of company, that particular register is in outside India. Can it, sir, is it okay to, it is allowed for company to keep the register of members outside India? Yes. Who permits the section 88 subsection 4 permits it. Okay. So now the question is, within how much time after opening of foreign register it is required to file the register of companies a notice of the situation of London office that they have opened it. So what is this? Rule 7 of Company Management and Administration Rules 2014. This says that company, it files form MGT3 to whom to register. And it should be what? They have asked the time limit. How much time? It should be filed within 30 days of opening of the register. So when did they open? November 1st. So within 31st within 1st of December, they have to file form MGT3 to the registrar. They have opened it. Yes. Question 11. Question 12. Satvikya Private Limited was formed on 25th April 2020. At the time of formation, it had provided in its articles that companies shall not be permitted to accept or keep advance, subscription or call money in advance. However, in August 2023, the need was felt to amend the articles with respect to retention of call in advance. Decide whether the provision inserted in the articles at the formation of the company can be considered as void. So what are they asking? Sir, when the company was formed on 25th April 2020, in their articles, they have not permitted call in advance. Yes, but later on after formation, it seems that it is required. Call in advance is required because a lot of people are ready to give the money to the company as call in advance. Now, if we have inserted, now the question is, if we have inserted at the time of formation itself, at the time when company got incorporated itself, that okay, that call in advance is permitted. You can accept call in advance. Will this be considered was void? That is the question. So what is your answer? Immediately when you think about this void, when first of all, when call in advance, section 50. But we are talking something about void. Even which section should strike in your head? First, section 50. What is section 50 saying? Tell me. If AOA authorizes calls in advance can be accepted. Yes. So is this void? This is what? This Companies Act 2013. Yes. Section 50 is talking about Companies Act. Now, will this be considered void? So now coming to Section 6. Now coming to Section 6. What is Section 6 saying? Any memorandum, any article, any agreement, or any resolution which is inconsistent with what? With the provision of Companies Act 2013. Then what? Whatever is mentioned in this MOA, AOA, article, agreement, and resolution, which is talking against the provision of Companies Act, that is considered as void. Yes or no? Sir, yes or no? Yes. Whereas, now tell me, Section 6. This is what? This is saying what? Section 50. Is it Section 50? Is it saying that okay, articles, if you authorize it, you can accept it. And article is also in the formation itself. If they have included that clause that okay, I'm permitting call in advance. Now tell me, is there anything void? No. Companies Act 2013 is allowing. Article is also allowing. No problem. If you have inserted in the articles at the time of formation itself about the clause of call in advance, there is nothing void. Yes or no? Yes or no? So there is, and if you see the RTP answer, they have said save otherwise provided. So what is this? A simple sir. In section 6 itself. In section 6, there is another section. What? That provision of Companies Act 2013. Provision of Companies Act 2013 shall have effect. Notwithstanding. So I'll write even if anything is mentioned in MOA or AOA and all. So is the provision saying okay? Is the provision allowing it? That section 50 is allowing that okay, article, if you authorize it, it's fine. But if you don't authorize it, if you in article it is not mentioned, then what? You cannot do it. Then you cannot do it. Yes or no? Yes. So which means if once article have said okay, I'm authorizing it, there is no problem. There is nothing void. Question number 13. The dividend amount received or receivable on equity shares held by Mr. Vaibhav for financial year 21-22 was as follows. Subhas Limited, dividend declaration date 25th August 2022. Dividend amount 800, where dividend was paid on 23/10/2022. Bandol Nidhi Limited, declaration on 4th September, 100 rupees. Dividend was not paid within the stipulated time period. No. Also, Mr. Vaibhav holds 100 cumulative preference shares of face value of 1 lakh in aggregate of Japan Tea Limited, on which dividend payable is at the rate of 8% per annum. However, during the financial 21-22, Japan Tea Limited did not earn any profit. In the context of aforesaid case scenario, please answer the following questions. What could be the punishment of the companies aforesaid in the table? With respect to delayed payment of dividend. Tell me, sir, when dividend should be paid? When dividend should be paid? As per section 127, it has to be paid within 30 days of declaration. Yes or no? Yes. So when it got declared, 25th August 2022 plus 30 days, what it comes to? 24th September 2022. It has to be, a dividend has to be given within 24th September 2022. But when it was given on 23rd October 2022 only it is given. So which means it has a date of what? How many days? 29 days. So now what is the punishment? What is the punishment in this late days? Simple interest of 18% per annum. So which is, what is the dividend amount? 800 into how many days? 29 days divided by 365 into how many percent? Simple interest 18% per annum. So which comes to somewhat, sir? Some very small negligible amount, but that is the interest amount. That is the interest, yes or no? Yes. Now, dividend was not paid within the stipulated period time. So they have not paid at all. So what to do? Just note, this is a Nidhi company. This is a Nidhi company. There's a provision for Nidhi company. What is the provision? That if it is 100 rupees or less, if it is 100 rupees or less, what you will do? The company will give in the local newspaper and also in the notice board of the company. Notice board of the company. Regarding non-payment, if it gives within 3 months, then there is no problem. Then there is no punishment. If they have not, given this, then the punishment will be applicable to this Nidhi company also. Yeah. So this is 100 rupees or less. We'll consider that they have done this provision. Yes or no? Yes. Or else if they have not done it, then the punishment is as aforesaid. You can do the calculation. Yeah. Yeah. Now, whether Jipanti Limited is required to pay dividend on cumulative preference shares for financial year 21-22. So what is this Jipanti Limited? Vaibhav also has invested in cumulative preference shares. Yeah. And this company, what? Dividend payable is at the rate of 8% per annum. But what's the problem? They did not earn any profits. So they paid? No, they don't have to pay. They don't have to pay. So the dividend is forgiven? No. There is nothing called forgiven. It will get cumulative. And when this Jipanti Limited earns profit, then they have to give dividend only then. Until that, dividend is not required to be paid. But there is one thing. Even for equity shares, you cannot give. First give the preference shareholders, then only you can give to the equity shareholders. Yes or no? Yes. What is question 14? Yellow Private Limited is engaged in the business of manufacturing premium quality rattle toys. They have a huge market for their toys all over India. The company has appointed its statutory auditors for the financial year 22-23. The engagement letter of the auditors was signed with a clause that fee to be mutually decided. The directors of the company have approached you to seek your advice for the provision relating to remuneration of auditors as per the provision of Companies Act 2013. So what is this, sir? It's talking about remuneration of auditors. Tell me, how will the remuneration of auditor be set? So if it is the first auditor, then board will decide. If not, who will decide? It will be decided in the annual general meeting by the members. Yes or no? It will be decided by annual general meeting the members. Any other amount of remuneration will be given? Yes. If apart from that any other expenses for this auditor has been, that also will be that also can be reimbursed to the auditor. Yes or no? Yes. So who will? So what is the provision relating to remuneration? In the annual general meeting, it will be decided. It will be decided by members. Yeah. Yes. Question 15. Sri Limited has authorized capital of 10 lakh equity shares of face value of 100 rupees each. Some of the shareholders expressed their opinion in the annual general meeting that it is very difficult for them to trade in the shares of the company in the stock market and requested the company to reduce the face value of each share to rupees 10 and increase the number of shares to 1 lakh. Examine whether the request of shareholders is considered as per the provision of Companies Act 2013. What are they saying, sir? What is this? Section number superb. Section 61, subsection 1, section 16, section. In section 61, subsection 1, it is talking about what? About this provision. So what is this provision saying? That they already have, how much do they have? 10 lakh, 10 lakh equity shares of 100 each. Yes. And request the company, and they have requested the company to reduce the face value of each share to rupees 10. So they have what? They have requested to reduce to what? Rupees 10. Yes, earlier it was 100 rupees. Can they do this? Can they do this? This is the question. What do you say? And they have told that, or you can they do it? So simply you can't just reduce it. You should also do what? You should also increase. You should also increase this. Hmm. Now, if you calculate this, how much is coming? 10 crores. Now, if you calculate this, how much is coming? 10 crores. Is there any problem? There is no problem. But there is even one more provision to it. This is what they are saying. The question itself is this. The question itself is this. What? That face value, reduced to rupees 10 and increase the number of shares to 1 lakh. You can do it, no problem. But there is one thing to keep in mind. In the memorandum of association, this will be mentioned. In the memorandum of association, this will be there. This is this particular in the capital clause, this will be mentioned. So what to do? You have to change the memorandum of association. Yes or no? Yes. And in section 64, you have to give it to the registrar. Yes, that I have done this change. Yes or no? Those and all is required, but you have to remember one thing. Let's say the paid up share capital. Let's say earlier, before, after. Before it was 10 lakh number of shares into 100 rupees each. Yes, where the paid up share capital was, let's say, 70 rupees and unpaid share capital. Unpaid share capital was rupees 30. Unpaid share capital was rupees 30. Now what are you doing? You're converting this into this 100 rupees, you're converting into 10 rupees. 1 crore into 10 rupees, which comes to 10 crores, which comes to 10 crores. Now, can I say this? This is fully paid. Can I say this? This is fully paid? No. You have to go according to the proportion. So, which means this you have to go by rupees 7 and this you have to go by rupees 3. Is it in the same proportion 70 is to 30, which is 7 is to 3? Is it in the same proportion? Yes. When you do this change, you have to see it is in the same proportion. You have to change you have to change the memorandum of association. Then you have to file it to the register, yes or no? This is section 61. Subsection 1, in clause D, we are talking about this. Now, okay. Question number 16. A Limited raised the security deposit of 80 crores on 30th June 2023 from public on the interest at 12% per annum, repayable after 3 years. The charge has been created within the prescribed time in favor of trustee of depositors against the deposit taken following the assets of the company as security. What is this? Charges created. Charges created. You have will you when security is given, why will the security be given? You have given deposit. What deposit? Secure deposit. So what it is secure? It is secure. No. What and all are the security? What and all are the asset? One is land and building. Next is plant and machinery. Next is factory shed. Next is trademark, goodwill. Now tell me what is the amount totally? So the deposit is 80 crores. What is the total amount of security? 55, 65, 70, 80, 90, 105. 105. Is there any problem? Is there any problem? No problem? Sir, I'm asking you again, is there any problem? No problem. Okay. Okay. First, I'll write this provision. Section 70, subsection 1. Company accepts secure deposit from public. Which has create, then what you do, then you create a charge. You create a charge on what? On its assets in favor of deposits. Yes. Deposit holder. Within 30 days. Within 30 days you have to do. Yeah. Yes. No. This is an important point. Amount of charge created on asset. Amount of charge created on asset. So what is this? What is the security? The total amount of security. The total amount of security should not be less than amount of deposits. So what is the amount of deposit? 80 crores. 80 crores. But what about amount of how much security has been given? 105 crores. So is it less? It's not less. Yeah. This is section 76, subsection 1. But when rule 6 come into picture, what kind of asset? What kind of security? Tangible. Only tangible security only should be considered. Only tangible security should be considered. So 55, 65. That's only 80 crores. What? 80 crores. So now how much is the tangible security? 80 crores. 80 crores is less than the amount of deposits. Yes. 80 crores. 80 crores, is it less than 80 crores? Is it less than the amount of deposit? No, it's not. But there is one more provision that security should be amount of deposit plus interest. So what is the interest? What is the interest? 3 years. So 80 crores plus 80 crores into 12% into 3 years. How much is coming, sir? some X amount of money, sir. Interest, which is, I don't have calculator, so I'm not doing this calculation part. So which means the amount of security which is tangible is 80 crores, which is less than the amount of deposit and interest, which is less than, so it will come around something around some 110 crores. It will come something around 110 crores. So this is less. The security is less. Now tell me, is charge created? No, it's not. It's not. The question is, decide on the validity of the charge created. Is the validly created? No, it's not. It's not created because security is less. Security is less. Yes. Now, we have finished Companies Act. Now we are entering into other law, Indian Contract Act. Mr. Sanjeev is dealing with the high quality timber. Mr. Amit wants to purchase the timber from him on credit, which is to be used in renovation of his house. Mr. Pramod gives a guarantee to Mr. Sanjeev for timber to be supplied by Mr. Sanjeev to Mr. Amit. Surety, principal debtor, creditor. Mr. Sanjeev supplied the required timber to Mr. Amit. Afterwards, Mr. Amit embarrassed and contracts with his creditor to assign to them his property in consideration of their releasing him from the demands. Okay. On due date, Mr. Sanjeev files a suit against Mr. Pramod for recovery of the payment of timber due to Mr. Amit. Yeah. Explain with reference to Indian Contract Act 1872 whether Mr. Sanjeev, who is a surety, can claim the payment from Mr. Pramod. I'm sorry. Who's this creditor? Can he claim the surety from? Can a creditor claim payment from surety, Mr. Pramod? What is this section talking about? Creditor. Section 134 of Indian Contract Act. What is it saying? It talks about discharge of surety. When principal debtor is released, or any act or omission of creditor which discharges principal debtor by legal consequence. How this happen? So how can an act or omission by creditor discharge the principal debtor? Tell me. By any act between creditor and principal debtor. Did any act between creditor and principal debtor came into picture? Yes. Principal debtor enters into a contract with creditor that Mr. Amit, who's the principal debtor, enters into contract with creditor to assign his property in consideration of releasing him from the demands. They are telling that release me. Release principal debtor like that, and you just have my property, but release me. Because what? I'm embarrassed. Principal debtor is embarrassed. Now tell me, when principal debtor itself is Discharge. Do you think that surety is not discharged? Surety is also discharged. Yes or no? Can now tell me, can Mr. Sanjeev, who is a creditor, claim payment from Mr. Pramod? No. Surety is discharged so that creditor cannot claim from Mr. Pramod, who is a surety. Mr. Vaibhav made endorsement of a bill of exchange amounting 35,000 to Mr. Rishabh. But before the same could be delivered to Mr. Rishabh, Mr. Vaibhav passed away. Mr. Sumesh, son of Mr. Vaibhav, who was only legal representatives of Mr. Vaibhav, approached Mr. Rishabh and informed him about his father's death. Now, Mr. Sumesh, who is willing to complete the instrument which was executed by his deceased father, referring to the relevant provision of Negotiable Instrument Act 1881, decide whether Mr. Sumesh can complete the instrument. What is it talking about? What is it talking about? So which section number? Section number 57. Okay, now what is that? What are they talking about? What is the question? Who passed away? Rishabh passed away. Rishabh passed away, yes or no? Now what is this? What is this bill? Order. Yes or no? Or yes or no? Is it an bearer instrument? It's an order instrument. So in case of bearer instrument, you have to just deliver. In case of bearer instrument, you have to just deliver. But in case of order instrument, you have to endorse it and deliver it. You have to endorse it and deliver it. Yes or no? Mr. Rishabh could not deliver it. Mr. Rishabh could not deliver it. But before that, he passed away. Mr. Sumesh, his son, can he deliver? See, as per section 57, a legal representative cannot deliver it. A legal representative cannot deliver it. So then what about an agent? He would have consider a person as an agent or nominee. He could, if he wants, he can do it. But a legal representative, even if it is a son, even though he endorsed it, he cannot do what? He cannot do it. Yes or no? So can he complete this instrument? No, he cannot complete the instrument. Yes or no? Yes. Question 19. Mr. Neelu Chandra was director in Laddu Sweets Private Limited. Once while dealing with supplier of raw materials to the company, she agreed to get some secret commission from supplier for making the deal. Afterwards, on finding the facts, the company had filed the suit against Mrs. Neelu Chandra. She contended that Section 166 of Companies Act 2000 provides a director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or his relative partner associate, and if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to that gain to the company. She contended that Section 166 is applicable to male directors only. She, being a female, will not be liable. What do you think? What do you think? So, what is this? Hmm? The woman, the female is saying that, see, this provision is only for me, it's not for female. So, are we talking about Companies Act? No. In Gender Clause Act 1897, it is being mentioned. What is being mentioned? We'll read that line. Section 13 of Gender Clauses Act. In all central act or regulation, words importing the masculine gender. What does this masculine gender means? So masculine means male. Feminine gender means female. Okay. Masculine gender shall be taken to include females. That's it. Gender Clauses Act is saying. So it is also applicable to Companies Act. So Mrs. Neelu Chandra, director in Laddu Sweets Private Limited, made an undue gain in the form of commissions in dealing for Laddu Sweets Private Limited, but she denied accepting the liability by saying that the penalty is only for male directors and not for females. So therefore, Mrs. Neelu Chandra is bound to comply with Section 166. Why? because it also includes female. It also includes female. Yes or question number 20. What is the meaning of without prejudice? So what is this without prejudice means? You would have studied in my classes a lot of times. Sir, what is this? It has, if I mention without prejudice, let's say a section, some subsection number 7. I'm talking something on subsection number 7, where I'm saying without prejudice to subsection number 5. So what does this mean? You have to also, by considering subsection 5 also, you have to comply with subsection number 7. That's all. But you have to comply both the things. You have to comply both the things. Yes or no? Yes or no? It's for example, in the answer paper, you have to write the answer. Along with it, you have to you have to write the question number also. Then you have to write the answer properly. Then only you will get marks the same way. Yes, you have to comply the subsection 5 and also subsection 7. Yeah. So this is what is without prejudice means. So this way we have completed RTP. Hope it was lovely and everybody loved it. And if there is any doubt, please mention in the comment section. I will take care of those doubts. And if you like this class, do like and subscribe and click a bell icon. Thank you.